I just got off the hearing for the State versus Jared Leisek regarding the um, intimate assault charges against a charge against a child. Um, and they had a motion to dismiss at the previous hearing, and so this was on the issues of whether the statute of limitations had expired based on the law when um, the crime is alleged to have occurred. And for the state, we had Eric Butler, and for the defense, we had Randall Richards, and Judge Mandy Larsen was presiding. And the hearing was held in Manti, Utah, via WebEx. And um, the defense had moved to have the case dismissed based on statute of limitations because they are saying that the um, case happened in conjunction with an incident of Jared Leisek taking his aunt's vehicle and going joyriding, and they contend that the um, incident took place in the sounds like it was late 80s, 1988, 1989. They're saying that he would have been 13 years old at the time, and we're arguing that the uh, case-setting president, Tiedemann, um, was the authorities that says it should be dismissed based on destruction of evidence, that the records from juvenile detention for that incident have been destroyed, and so they can't offer those as exculpatory to show that he was 13 at the time. And they said that under, I can't, not sure if I got the name of the case on that. I think it might have been State versus Lusk. Um, they said that the defense alleges that the if the assault took place, that according to the state's information, that um, it was consensual behavior based on the fact that bribes and threats were used in order to get uh, the alleged victim to comply, and so that it was voluntary, and that that if it happens and they're under 14, then it's a consensual act, and both parties are below 14 and so forth. Um, so let's see. Age. Um, so if the age difference is 7 years, 6 or 7 years, if he was 13, let's say, then she would have been what, 7, and that's a far cry different than the case that they stated, which where there was only a 1 year difference in. And so um, the Judge Larsen ruled that it wasn't analogous, and said that the information on which the court has to decide is based solely upon the state's information, and therefore um, the information contained in there says that it occurred during the year of 1992, between the date of January 1st and December 31st. And so the statute of limitations at that point um, would have said that it would have been 4 years from the date of it being reported to the police, and the report was made to the police in, I think a year ago in 1920, I mean, 2022, and so therefore the statute of limitations has not expired. And let's see, what else? Um, Also, the Tiedemann decision, the state argued that the destruction of evidence that he trying to use as a basis of the case being dismissed was basis there was a homicide case. They destroyed the guns. They destroyed the rape kit. They destroyed all the physical evidence that had to do with the case. And so this here is not something that the prosecution is responsible, and there's no mention in the Tiedemann case regarding stuff happening over due to the passage of time. And so the judge ruled that based on the info again, and the fact that we haven't had even the preliminary hearing yet, that she has to go by what is contained in the information. Therefore, the motion to dismiss has been denied, and have set the preliminary hearing for April 5th at 3 p.m. It is in person down in Manti, April 5th, 3 p.m. So, guess I'll have to hop in my little car and go for a road trip. Um, that is, if I'll have to find out if they'll let me in to hear it, because last time they were saying that the case involved minors and so couldn't be heard by the public, but that was 30 years ago. The people in question are now middle age, so we'll see what I can work out with the court, whether it is um, something to drive down for or not. It's a good question. Okay, so I will update in April as get closer to the court date. So that's it for today, and thank you very much. We'll see you later. Bye bye.